Moving from the question of whether or not you prove your infringement case and decide you have a valid and infringed patent this afternoon into questions of what is your patent worth, either outside the litigation context, which is the subject of our next panel, or in the litigation context, which will be the subject of our final panel. Ron Laurie from Inflexion Point Strategy is chairing our panel, and I will let him introduce our speakers.
Thanks, Mark. This panel is really a focus on IP and patents in particular as business assets rather than as legal rights, which is not to say that legal rights aren't important, because if one were to unequivocally declare that the patents in question would never be enforced, the value of the asset would be zero. So what we're going to examine is patents as an asset class to be traded upstream of the enforcement activity. It's a very distinguished panel. You've already met Ken Correa. Ken has a distinguished career as a patent litigator. In fact, he started as a federal prosecutor. A real litigator, one might say. And spent some time at McDermott and
too many
firms. Okay, and is now vice president of IP for the U.S. operations of the Samsung IP Center. Kevin is vice president of acquisitions for RPX, a title which he previously held at the other big aggregator, Intellectual Ventures, and before that, he comes to us from the real business community. He was at McKinsey. And Lisa is a managing director of Ovidian, which is a patent transaction intermediary. Is that close enough?
Close enough.
Okay. And Lisa's also a Silicon Valley veteran, having been at Brown & Bain and Wilson, and most recently at Yahoo. So with that, let me open the discussion with the question of whether patents really are an asset class. You hear a lot of discussion about patents being an asset class, and that's easy to say, but the question is that really true? And this is more than just a question of academic interest, because the extent to which patents are a real asset class in the traditional sense of the word determines the level of interest on the part of institutional investors. And I know we have a couple of institutional investor representatives in the room, so that's good. I'm sure they'll have something to say. And the question is it really an asset class that can be efficiently traded, as I said before, upstream of the enforcement? So let me kick it off by sort of saying what I think the attributes of an asset class are from a financial investment point of view. There must be valuation fundamentals. There must be a certain comfort level in the ability to value the asset. We're going to spend a lot of time on valuation and the difficulties involved in valuation. There must be transparency and price discovery. There needs to be a way where participants can compare the value of their transactions to other similar transactions. Again, we're a long way from transparency in the patent market. There must be liquidity. There must be the ability to get in and out relatively quickly and easily. So that's my view of what creates an efficient trading market in an asset class. There's also the concept of value, and what does value really mean? If I had my druthers, I would drop the word value altogether and use the word worth. Because value implies some absolute indicator that extends, across all cases and all buyers. The fact is that nothing could be further from the case, and we're going to talk about that. The word worth really focuses your attention on what I think is the key element, and that is worth to whom and in what context. And those attributes vary widely across a whole range of valuation transactions. And then maybe along the way we can compare this nominal asset class with the ones we know about, like real estate, commodities, stock, antiques, fine art, and even derivatives. And I hesitate to use that word because there are a lot of similarities between patents and derivatives. There are also a lot of differences. So let me kick it off to the rest of the panel on, is this really an asset class, or are we just pretending?
I'll jump in. I think we're making progress towards that front. I think it's becoming more of an asset class, but I think fundamentally, when you're relying on the legal system, and the vast majority of transactions rely on the legal system to set price, it's going to prevent it from becoming a true asset class. We've got to get to a point where more and more of the price and the conditions of a transaction are set outside of court. Because it really is, if you call it an asset class now, it's the only asset class where pricing is set in courts, primarily. And so I think that's the big thing that is missing, is a little bit to your point about it, can you move it upstream on it?
Well, Lisa, what about the importance of context in determining value?
Well, I think, context is critical. And I think, in my view, I agree with Kevin that we are moving slowly towards a world where patents are more like an asset class, but the fundamental nature of a patent is that it's the power to exclude. It's not an affirmative asset. And so, to me, the fact that all a patent does is give you the right to do something to somebody else is going to keep it from ever being completely a neutral asset class. I think our investment models and our way of valuing that right will get more mature and more standardized. But in my opinion, it's never going to be, just another kind of financial instrument because of the nature of patents. But context is absolutely critical. And I think even now there are contexts in which a patent is much more like a traditional asset class than in others. And it just depends on who's looking at the patents, for what purpose, and what level of scrutiny is going to be placed on the transaction. All of those are just absolutely fundamental, critical questions that drive what valuation you use and how you think about the asset.
Well, let me take some issue with the characterization of patents as not being an asset class because they're a legal right. What about options? Options are nothing more than a legal right, and there's a big market in trading options.
But they're more consensual. They are an option to do something in the future. It's not something, to Kevin's point, it's not something that depends on a court system to enforce that right. And it's less of a disputed right. With a patent, what does it cover? I don't know. I have to wait until a court tells me what it covers. Do I need a license? You say I do. I don't think I do. So there's always that ambiguity, and that the taxing element of it. A lot of the assertions are coming after somebody else has already invested the time and energy to solve the problem. So it's much more of a contention-based, exclusion monopoly power that I think will always keep it out of just being a purely neutral financial instrument.
What about, so it sounds like another way to describe what you're talking about is risk. How to quantify or estimate risk. So what are the kinds of risks that are specific to patents? In other words, the financial community is very good at evaluating risk. For example, venture capitalists are good at evaluating technology risk, whether or not the technology will work. Adoption risk, whether even if it works, there'll be a market. Execution risk, where even if it works and there's a market, the team is, for some reason or another, can't bring it to market. What are the risks in patents?
Well, I think the issue is exactly what Lisa just pointed out, that patent is a negative right. You cannot even practice your own invention covered by your own patents because somebody else might have a claim against your own invention. So the only thing you can do with the patent is that you can stop somebody from practicing the covered invention. I think this kind of comes up in the context of startup companies. When we are trying to buy startup companies, oftentimes, only thing they really have worthwhile besides their people and maybe a couple desktop computers are the patents or patent applications, more like. So in a sense, I guess you have to say they're asset class, because otherwise you're saying the company has nothing. But so it is an asset class, but precisely because it is a negative right, valuation is just not like, it's not going to be like any other asset class. So it really goes on to, but in terms of how you assign a value to those patents, it goes straight back to what you're talking about. It really determines, I mean, you should really look at it as a risk management issue for, let's say, for big companies who want to buy a startup company that has nothing but patents as assets. And that is, if that big company want to go to that route in the future, then they should buy patents in that covering that particular technology. Now, in terms of how you value patents at that point, well, it goes back to the traditional method, that VCs use. Whether this technology can be commercialized. Once it's commercialized, will it be adopted by the market in a sufficient scale? And what's going to be revenue? And if I don't buy those patents, what's risk to me? I mean, there are potential injunction damages. I mean, those are the things that you have to look into. So I guess the risk to patents in that instance is that if some big industry players or all the industry players are not interested in your technology, then your patents are absolutely worthless.
Yeah, I would say in this market, though not in a perfect market, the question is not whether industry players are interested, but even more specifically, whether industry players are infringing. Is there any market for patents that aren't currently being infringed that you see?
There isn't any. I mean, I had an interesting conversation with a small company that has some fascinating technology on how to make circuits perform better. And he kept saying, well, we have all these patents in the application you need to buy, otherwise you might be infringing in the future. It's like, hang on a second, are we using that technology? No. Is anybody out there using that technology? He says, no. Okay, then your patents are worthless.
End of the conversation.
Yeah. Why? Especially if you keep that kind of attitude, I'm not going to use that technology, period.
Yeah.
Right.
I mean, I think the only exception I would say the vast majority of the market is all about is someone infringing. Because again, if you look at it statistically, aside from the big published reports about operating companies buying, the reality is most of the buying is from NPEs, and they care about infringement because that will allow them to monetize and sue. Now, I will say the only exception is every once in a really great while you can find an operating company that is interested because they know it's not so future state. They know it's on their really near-term roadmap, and that is the direction they plan on going. So they know that it's very high probability they will be infringing.
Well, let me challenge your statement that most of the buying is done by NPEs. Are you measuring it in transactions or dollars?
Transactions.
What if you were going to measure it in dollars?
Well, if you measure it in dollars, it would be skewed because of what's happened over the last year with Nortel and with, if you call MMI just a pure patent acquisition, obviously it's skewed because of that. But I think traditionally, it still is driven by the NPEs. Again, those aren't. We've said this a lot, but those were transactions that were driven by unique strategic interests of corporations. Those weren't the everyday transactions, despite what everyone wants to think.
Then what on the future, I actually think there is a market for future technologies. It may not be as visible or as large, but a lot of our clients they have information asymmetry. They know they're heading in that space, and they want to go out and proactively purchase up the relevant assets in that technology area, both to prevent a defensive situation when they get there, but also just to have the ability to protect the features that they're building in. So there is a market, but I think it is the operating companies for obvious reasons that are purchasing there. And then we're seeing aggregators that are looking ahead 3 to 5 years and looking to build a portfolio for the future technologies because they see the market right now is just very saturated, the smartphone wars and whatnot. And at some point you just become, take a line goes to the left, I'll get to you when I get to you, but they're looking to seed the next round of investments. And so they're trying to guess what technologies are going to be really driving the money 3 to 5 years from now. So I think in both of those two instances, we are seeing a lot of market activity around the future technologies.
Yeah, I absolutely agree. I see a lot of this going on in the area of large companies moving into new technology areas. One of the things that they'll do is go out and see who are the sort of foundational patent holders in that area, and they tend to be small and medium-sized entities. And the interesting thing is when you approach those entities and you say, on behalf of the large company, and you say, how would you like to sell your patents? The reaction is pretty universally, are you crazy? Why would we sell our patents? What would our company be worth without the patents?
Right.
And then you say, well, would you like to sell the company? And they say, when can we talk?
Right.
What are you doing on Tuesday?
Yeah.
And this is a very interesting trend of patent acquisition moving into the M&A area. And I think Google Motorola was a highly visible example, but in my mind, not the first. I would say that maybe the first in recent years was HP Palm. Mark Hurd was quoted after that deal as saying that it was primarily done to get the WebOS IP. Now, what he meant by IP was a little broader than what we would think of as IP. But clearly, it was a heavily IP-driven deal. If I can tell a war story about how I got into this business, in 2003, I was I was an M&A lawyer and doing a lot of sort of high-value billion-dollar deals, and managing the IP sides of the deals, and a company called Intertrust, which I'm sure a lot of people in the room know about, came to my firm, to Skadden, and said, we'd like to sell our company. And the head of M&A in New York said, no problem, we do that every day. Now, the problem was that the only assets in the company at that point, this was obviously after the bubble, the internet bubble burst, the only assets were a very nice patent portfolio in the area of digital rights management, secure content delivery, and a lawsuit against Microsoft for infringement of those patents. Those were the only assets of the company. So we went out and had meetings with the usual investment bankers that the firm dealt with, the big guys, Morgan Stanley and Goldman Sachs and JP Morgan, and the conversation was virtually identical with each one of them. And after 10 minutes, the bankers are sitting across the table saying, you mean the only assets in this company are patents? And we would say, yeah, and then there's this lawsuit against Microsoft, and they just went, we don't know what to do with that. Our valuation methods don't work, we don't know what to do with it. The end of the story is that we found one who not only would do the deal, but they took a part ownership interest in the assets, and they were sold to a joint venture of Sony and Philips for $500 million, which was real money in those days. Now anything less than $1 billion is just nothing to pay attention to. The point was that those patents had specific strategic value, especially to Sony, because Microsoft had announced that they were going to put transaction processing ability into the Xbox so that you could not only download a game, you could pay for it on the fly, essentially, as you downloaded it. And Sony was going to do the same thing with PlayStation 3. And so this became a very, very strategic issue, even though there were no real assets in the company. And the end of the story is that 8 months later, after the sale, the lawsuit with Microsoft was settled for virtually the purchase price of the company. So they were even after the first transaction. And that convinced me that under the right circumstances, you really could do serious deals around IP assets. Okay, what about the difficulties in valuation? What's a comparable? How do you figure out what a comparable is to let's take the easy case. You got a single patent. How do you know when another patent is comparable in terms of valuation?
Again, from my perspective, right now at the moment, the comparables are all, it's information held by a particular actor in the ecosystem. So if I'm an operating company and I'm purchasing patents, and I think, I bought my last litigation gem for $1 million, and I see another patent that has the same kind of strength in terms of claims quality and drafting, clean prior art history, present infringement that's detectable. In my mind, that's a comparable patent. And the same thing if you buy from the same seller. If you know last time you did a deal with that seller, this was the range, this was the number of patents you bought, and this was the average price, and you take information you got from that transaction, and that forms the comparable for that deal. And I think there's more and more of this type of institutional knowledge being developed as this acquisition market is unfolding. It's not comparables like the MLS listings or anything else that you can see. It's very participant centralized, and again, context based.
And wrapped in NDAs, so that you can't go to a public database other than Edgar in case of material transactions to public companies.
No, that's true. That's true. But it's in people's brains, and people in this valley move around a lot, and I think that there's a sense for comparables, at least on the patent acquisition side of the house, just given the number of transactions that we're seeing be done, and where the negotiating positions are not, there's not that much variation in it. So in my mind, there is comparables. They may not be publicly known, but if you've participated in any of these transactions, you catch on pretty quickly.
And obviously, the more transactions, the more data, as in the case of Kevin's former and current companies, right? Huge amounts of data.
Yeah, I think there are more players that are really making an effort to both aggregate that data and talk about that data. I mean, we at RPX, data is a core foundation for us going forward, and we are more than willing to share that data because we think it's good for the market. Again, if you do have a goal of driving towards a more efficient market, you need transparency, which is what this industry has lacked for a long period of time. But I think, to Lisa's point, I mean, the valuations, it's so contextual. Yeah. It's who the buyer is and what you're planning on using those assets for. We obviously at RPX have our own way of analyzing patents and coming up with a value, and we think that's representative of a lot of other folks, but it's different if it's an operating company needing it for perceived strategic importance.
Well, given that every one of those transactions is most likely wrapped in confidentiality obligations, how do you make the data public? We publish what our average price we pay per patent. It's all, it really is aggregating. It is more difficult to do it on a per transaction basis, and honestly, I don't think doing it on a per transaction basis is valuable because we do deals where we're paying, our average price per patent on an individual deal maybe $5, maybe $10 million. But we're also doing deals where our average price per patent is $5K because the seller's got 100 other patents that they're throwing in with the deal that really aren't worth anything. So I do think you have to look at a bigger data set. It doesn't make sense to do it on the individual transactions.
One problem I see with the comparable approach is that each patent is going to be differently situated. Let's talk about DRM patent. Obviously, if a same quality DRM patent belongs to IBM versus Intertrust at the time when it did not have any licensee, whereas IBM had zillions of licensees.
Mm-hmm.
Yeah. Obviously, value of that DRM patent belonging to IBM is going to be different than similar quality DRM patent belonging to Intertrust. Mm-hmm. So I think that points out that even with the transparency, and I really don't see transparency coming into the marketplace anytime soon, but even if it can achieve that, it's the transaction cost of determining the value of any patent is going to be quite high because you have to look at those licensing obligations.
Right. And what about the role of who the buyer is in terms of affecting value or worth? I mean, for example, a buyer that's already got 1,000 patents in that area versus a buyer with the same exposure that has none. Tremendous difference in value,
Absolutely.
right?
Yep.
Absolutely.
By the way, feel free to jump in. I think there's a lot of expertise out there on these issues, and we'd like to hear it. Let me just offer what I think is what may be, I think it's too early to tell, kind of the most significant change in patent valuation. So we look at patent valuation in terms, or patent monetization, value extraction, let's call it that. I hate to use the word monetization because it's so top-line revenue focused. There are lots of ways to generate value. So we look at it sort of from an accounting perspective. So there's value extraction that is reflected in the P&L, in the income statement. And that's generally easy to measure. So there's top-line revenue. There's so-called value licensing programs where the whole point of the acquisition is to generate license fees, and it's easy to measure success in that regard. That's sort of top-line, level one. Level two is cost reduction in terms of defensive acquisition to reduce the outflow of cash to third parties in terms of license fees. Not so easy to measure because you have to figure out what you would have paid if you didn't have the patents. So those are both sort of P&L level stuff. What I think may be happening in the marketplace, especially in the mobile device marketplace, is we may be moving to levels 3 and 4, and let me tell you what I think those are. And those are the strategic levels. Level 3 is acquisition to maintain or increase market share. And level 4 is acquisition to increase enterprise value in the case of M&A, for example. You really can't talk about IPO because early stage companies really don't have the kind of patent position that would affect it, although they could always buy their way into a previous patent position, as recently happened when let's see, who was it that bought the Friendster? Who bought the Friendster? Was it Facebook? Yeah, Facebook paid $40 million for the Friendster portfolio. Why? Because Friendster was sort of early in the game and had the early priority dates, and therefore potentially the most powerful patents. So you can sort of buy your way in at the end. But generally, I think what may be happening is this kind of shift from buying for financial purposes, which is all about licensing revenue, either incoming or outgoing, to controlling market share. And we're not going to know until we see what happens to these injunctions that are issuing in the various fora around the world to the players, and we all know who the players are in the mobile device space. And in general, as far as I know, and maybe somebody else knows differently, there have been very few cases historically where companies have enforced their injunctions. Usually an injunction is just a way to raise the settlement value of the case, significantly raise the settlement value. The only one I can think of in recent times was Kodak Polaroid,
Yep.
where Polaroid actually put Kodak out of the instant camera business. Now, are we going to see that happening in this market? Are we going to see cross licenses and royalty and balancing payments going in every which way direction, or are these companies really going to start to enforce exclusion orders and permanent injunctions? And to the extent they do, I think we're moving into a whole new era of patent value. because a point of market share in some of these markets dwarfs any kind of a license fee that anybody can imagine. And so it's really going to be interesting to see what détente looks like in this world. And I think it would be very interesting.
I would just, I tend to, I think I'm more of the camp that what's going to end up happening with all this is it's just going to be large cross-licensing deals. I really don't envision, I mean, it's an interesting thought to think that you're going to leverage patents to really maintain or increase market share, but I really don't think, I think the product forces of the market are going to push that out of the way. I mean, I don't think companies are not inventing in certain areas because they don't have patents in that area. And I think the market will, the consumer, particularly in the consumer market will adopt what they want. And I personally think it will all end up in cross licenses. And I also think part of the complexity too is when you're dealing with a cell phone, we've all talked about it, when you're dealing with a cell phone example, you're dealing with so many thousands of patents in that device that, to get someone actually at the end of the day not be able to sell a cell phone would be very difficult to do.
Well, yeah, but it's not going to be that someone won't be able to sell a cell phone. It's going to be that someone will not be able to sell a cell phone with a feature that you turn it on by swiping your finger across the bottom of the screen.
Right, but I think that's my point, is that I don't think that there will be a single patent or a single case that will involve a feature that is so core that it will fundamentally make a difference in market share. That's why I think it will end up in cross licenses, because everyone will end up having the patents on certain features and then you'll cross.
Well, and even so, even if you get the injunction like that, the target of the injunction will just go by the company that it needs, and it may be an 18-month cycle before they get their injunction against the person who was enforcing the injunction, and you end up at a cross license.
Well, I'm assuming we've gotten, at some point we get to that sort of mutually assured destruction level. Although what I always tell people is that in the Cold War, in the U.S.-Soviet Cold War, before it was over, each side could destroy the other side 22 times over. Parity didn't end that particular Cold War, so it's hard to know when enough is enough, right? And then there's another wild card, and that is, I don't know if anyone is here from Apple, but Apple is not a company that's known for licensing its core IP. And everybody's familiar with the Steve Jobs quote about global thermonuclear war, and how will it end? Yes.
Yeah, back to the points. Actually, from technical point of view, I have comments. Probably the question there. I think from technical point of view, I'm on the patent evaluation on technical point of view, not legal side. Eventually, I have to position all the patents into somewhere in the patent tree. So back to the Apple case, okay? We have 1,000 million patents in the mobile device. But for me, very clear, I only have 4 trees. One is transmission. Second is the user interface. Third one is power management. Fourth is application OS, right? So if you look at Apple case, very simple, only 4 trees. And then most of the patents are the leaves, not in trunk side and root side. So if you look at Apple case, Apple mobile phone 4 trees, right? Apple only have 2 trees. One is user interface, the other one is OS. And the transmission, they have to working with Qualcomm. And then power management, you have to work with Broadcom, or the other one. So the story's life is very simple, okay, from technical point of view. So that's, I mean, for the Nortel case, they have 1,000 patents there. And for me, I spent 3 months to review all the Nortel patents into the trees, 6 trees. Motorola, 4 trees. So then you have lawsuits, very simple. If you are behind this guy, you don't worry about it. Because if guy infringe your, invalid your patents, this guy is dead automatically. So that's the technical point of view. I'm not sure, probably stupid in the legal point of view. But if your legal and the technical work together, the evaluation is based on the whole, not just the patents. And the other one, we have to learn from Qualcomm. Qualcomm very smart, because when you're talking about evaluation, right, value, right, one value is patent. The other value, don't forget it, is a technology direction, future, trend. Qualcomm file CDMA or BCDMA or in the digital as a trademark. And it's you bring all the people in the CDMA come together. And iPhone, very smart. Steve Jobs, very smart, because he defined I. I means what? User interface. A user-oriented. Also the information in the future. I means everything, right? So around I, you have very strong trees there. It's not just patent. Patents itself is useless, nothing. But when you have environment very strong, Apple is the I company, okay? I means what? You think about it. And then, so when we talk about patents, from technical point of view, I'm a technical guy. So when talking about patents there, I have to think about a trademark. It's a technology trademark. It's not product trademark. Then combine together very strong CDMF force, very strong I force. Then it's very, very important. So probably it's stupid at some point. Maybe it's stupid, but when I talk about evaluation, I'm talking about a whole bunch of trademark patents work together is a tree, very strong tree. And depends on where the tree, leaf side or root side, then it's ideas. So probably it's question or probably it's comments, I'm not sure. Thank you.
Any comments on that?
No, I think, in a perfect world, that's how the patent system would be viewed. But right now you can buy one crappy patent and go make a whole lot of trouble for a lot of companies, and you've got a whole ecosystem of players who are taking patents out of the innovation context in which they were originally intended and using loopholes in the system and the cost to kind of wreak havoc. And so it's the collision of your view of the world and how technology and product and branding and all works together, and how in a true market economy the players would find equilibrium. But you have this whole other side of the equation, and you've got players all along the spectrum that have really inhibited the promotion of the patent ecosystem that you described. That's my view.
And the market, the sort of tree analogy is affected by the market because, for example, you say, well, when you think of transmission, you think of Qualcomm. Well, not anymore. Not after Google bought Motorola. Not after Rockstar bought Nortel. In other words, the tree can change in an instant in terms of who the players are.
And I guess another thing is that, I'm on the patent buying side, but I'm also on the patent litigation side. So it is probably good to have that type of overview of the patent portfolio, but when you're actually trying to enforce patents, there's other kinds of analysis you really have to get into before you feel comfortable as a patent litigator as whether this patent is worth asserting. That is that you really need to go through claim by claim analysis, and then you have to go through the file history to make sure that there are no issues that's gonna come back and surprise you. And then you also have all these licensing relationships. So I guess that kind of opens the door to our next topic, which is that, when you have, let's say, patent portfolio on the market with, let's say, several hundred to several thousand, even tens of thousands of patents, how do you actually evaluate that kind of a massive patent portfolio? Obviously, it's going to be very difficult to do a sort of litigation-specific analysis of each and every patent in the portfolio. And you guys are in the business of buying those patents, so I'll let you guys answer that.
Yeah, my personal view is a lot of those big portfolio purchases are fear-based. Just thinking about the Nortel portfolio getting carved up and put into the hands of 250 different types of NPEs who are all coming at you from all sides, I think there's a huge premium to the consortium purchases of these big portfolios to just knowing with certainty that they don't have to worry about all those, and a lot of those very high quality patents, maybe not all of them, but there's certainly enough of them where if you have to face each one individually in a separate litigation, that could really be problematic. So I don't know that to bring us back to the context in that purchase, I think the Novell consortium purchase and the Nortel, there was definitely a part of that was just we don't need to look at each individual patent and decide its worth and then total it up and make an offer. It was just, it's worth it this much to just take this whole bunch of patents off my radar.
Yeah, and I think when you hit on a good point when you're talking about analyzing a very large portfolio, it is difficult to do. I think it's doable, and I think you do have to make some assumptions. But when you're trying to analyze 30,000 patents, you do have to. It's a very much at least we in RBX approach it. You do a triage of the portfolio, and you actually can quite quickly get it into relevant sectors, product sectors, and you can bubble up to you can make some assumptions on what's good and what's not, and then at the end of the day, you do have to read the patents, I think. And I think when you're getting the really large portfolios, it's not gonna, the strength of one individual patent's not gonna swing it one way or another, but you have to get a sense of what's the relative strength by sector. But it's not necessarily, you're not evaluating, you're not saying, well, the 987 patent in this set of 30,000 is worth, $2 million, and the other one's worth nothing. Like you have to make some assumptions, but
Well,
you
and
can't
also, if
do
you have a
it.
back end, if you're planning to, yourself then turn around and sell some of the assets, you're going to get part of your purchase price back. So it's one thing if you're buying to hold and then either monetize or just absorb that cost, but it's another thing. A lot of these consortiums, they buy the patents and then they have a draft and then everyone gets a license and then they can release them back out into the ecosystem. And so if you're going to get that back end upside, I think it takes some of that pressure off to justify and analyze each and every patent. But I think at some level you do triage. You can apply some litigation assumptions. I think people who've litigated kind of have there's some rules of thumb. If you have 200 patents, probably 5% could pass Rule 11 and be thrown into litigation, and then of that 5%, maybe 1% of those would actually bypass summary judgment, and you get a verdict on it. And when you can apply some of those litigation rules of thumb or assumptions on top of the triaging analytic techniques, I think you can come up with. You can at least satisfy your management that you're not, you're buying something that has value.
Well, part of the process can be managed. For example, if you're a buyer, especially a buyer with some clout, you can say to the seller that's offering 5,000 patents, please identify the 20 best. And if you don't, we're just not interested. That has to do with the relative bargaining power of buyer and seller, for sure, and of course the need of the buyer is relevant. What about software-based analytics? There's a lot of software around that will give ratings to each patent in a huge portfolio. Does it work?
Sometimes, not very often.
No, to come up with an exact price, no. They can be useful tools, again, to bucket patents into relevant sectors, but at the end of the day, you have to read the claims, and it can be to varying degrees. And I think Lisa's dead on where you can just make certain assumptions, but you still at some point in time have to read the claims.
Right. Yes. Go ahead.
Question about valuation vis-a-vis antitrust approval, because what your background, Ron, is in M&A before you moved over to this side of things. But all of these transactions are dependent, or many of these transactions, as in the Nortel case, are dependent on antitrust approval. How does that factor into the valuation on these level 3 and level 4 acquisitions?
Sure. Well, as an M&A lawyer, my first reaction is that you can sort of engineer around antitrust problems by clever carving up of what you're trying to buy. And if, for example, you run into problems because you're buying patents plus an operating business, and if what you really want are the patents, then you can start to think about how to divest the operating business as a part of the original transaction. And maybe if that's what would have happened in the Google Motorola case, if regulatory approval was not granted, as it was, maybe they could start thinking about how to do that. That's the way M&A lawyers think. There's a backup plan if they don't get the regulatory approval. What do you do? But to the extent you can't do that, it's a really interesting point. Is there a risk factor for not getting antitrust approval? And if so, how do you apply that risk factor? I'm sorry, a discount factor. Because the way traditional valuation experts work is by risk-adjusted net present value of the future royalty stream generated by the patents. Whether or not the buyer is the one that generates those royalties doesn't matter. because that's the difference between viewing it as a right and viewing it as an asset. If it's an asset, you could be 3 parties upstream from the ultimate enforcement, but that's still the way you value it, by that future royalty stream, because that's the way a buyer is going to value it. So is there a discount? Is there some kind of a discount factor for not getting regulatory approval? I suppose there is, but
I mean, you can always negotiate some sort of contingency, that if you don't get the approval from the DOJ, then you can pay some fees and to get out of it. But the thing is that typically the antitrust issue arises when patents are used for anti-competitive reasons. I mean, patent itself is a government-granted right to exclude some other people. So by use of your patent right alone is not going to create antitrust issues. But it becomes a problem when there's some attempt to monopolize the market, or there's a concern. So in the context of Novell transaction, I think DOJ required EMC not to take any virtualization patents from that portfolio. That was one of the conditions for them to approve that transaction, because there was enough concern that EMC had enough patents in the virtualization field, and if they add a couple more, they could potentially block anybody who wants to get into virtualization field. But those are things that if you really think through, then you can probably anticipate before you actually do the transaction, and probably can prepare for those type of contingencies.
yeah.
In Ron's career-changing example, how is it where you had a lawsuit against Microsoft by a company that didn't have any business, and in Microsoft's view, that was a case where they may win by attrition, to a deep-pocketed owner that could enforce the lawsuit. How do you value the effect of the owner having a deep pocket to be able to enforce, or having the enforcement history? I know IV's interim effect has gone, since they've started filing lawsuits, has gone up greatly. So how do you value the value, if you will, of the owner or enforcer of the patents?
Well, I mean, so it depends what the impediment is to enforcement. For example, in AST's case, they have a sort of a built-in rule that they will not enforce, and that worked against them in this recent case of involving Limelight, where Limelight filed a DJ action against AST, knowing that they couldn't counterclaim. They were just helpless, and the case settled in, I don't know, a week or so. If the reason they can't, if the impediment to enforcement is financial, there are plenty of alternatives available these days. Contingent fee, patent plaintiff, lawyers, firms like Altitude and others that will finance the litigation. So being a small plaintiff isn't as much of a problem as it used to be. So the question is, what's the impediment and how do you deal with it?
But I do think it actually is an interesting element of trying to establish risk, because I do think if you take the exact same patent, and if you could do this, if you took the exact same patent and in the hands of player A versus player B, their characteristics will make a difference as far as how you perceive the risk. This happens all the time with counsel. When we look at a litigation that's impacting our clients, and and there's certain counsel are representing, like an Ed Goldstein, who is known for settling everything in the first year, going after really low dollar amounts. If that exact same patent was in the hands of being represented by McCool Smith, it's a completely different risk profile. So I do think it does make a difference, but I think to Ron's point, there is absolutely financing available, and so the money issue is less of an issue. But we do actually see it come up every once in a while, because what actually is happening is it's more smaller inventors or small companies who are looking to use proceeds to launch their next venture or to keep the lights on in the business. That's when it happens more regularly, not with the big
And I think that issue is in the buyer side. They need to be self-aware enough to understand their risk, their own risk tolerance, and how much money they're willing to invest in terms of monetization. And you got to know your management of your company if you're thinking about buying a patent and doing something with it. If you know that they'll get nervous right around Markman and want to settle. It's very different from a management that's ready and willing to go all the way to the federal circuit to enforce their patent. So I think it comes up in a variety of different contexts once again, and just being aware of the issue, I think, is important in valuation on both sides of the equation.
Tal?
When you're looking at the value of patents, specifically in large portfolio, it's clearly you have some patents that are really good and has value, and you have a bunch of them that's not worth the paper. When you're doing the deal, how can you evaluate what is the right one or what is not? And how the example like we can spoke in quite a bit is the Nortel patents. I can admit I created the patent committee for Nortel, and I led it for 11 years. So I know each and one of them by heart because I was behind there. A lot of them are garbage. Absolutely stupidity, but hey, but the lawyer said, look, we have to file and we have a budget. And we have to finish the budget because if we'll not finish the budget, next year we'll have less.
You're describing most of the large tech companies in the world. It's not Nortel.
So how can you you have some key inventors, they put, I will not put names, but 300, 400 patents that absolutely brilliant. But most of them is not. And how can you evaluate what makes sense and what not? Specifically in large portfolios.
So I think, to Kevin's point, you can triage the portfolio. I mean, everyone knows that's a fact about most large portfolios. There's a few gems, there's a lot of bulk, there's a lot of crap. And I think there are ways, very cost-effective ways, to quickly triage a portfolio and at least bubble up the patents that are most likely to be the gems. At the end of the day, you have to read the claims, you have to read the spec, you have to read the file history. But for example, one metric that's very easy to see is how many foreign counterparts were filed for a particular patent family. Because if there's lots and lots of them, that tells you that somebody at that company thought that patent was worth that extra level of investment. And that's something you can see very quickly. So there are metrics that you could use some of these software programs if you know what to look for. You can very quickly kind of get an overall view of the portfolio and what percentage of the family, of the portfolio was subject to this heavy investment. Is it just a random scattering? I mean, you can really size it up pretty quickly. And then you assign, you can have a rating system, and you can say, we think this many are high quality gems, and we attribute this much per patent to that level of quality, and you can bubble it down, and then you come up with an average price across the portfolio that, it's an average price, but it doesn't tell you kind of the weighted mechanics that are inside.
Because you have a problem with this system, and it's related not to the legal issue, it's related to the business issue. Mm-hmm. When you are creating this patent, if you belong to a well-funded business unit that has a lot of money, they will say, sure, we'll file 50 patents, and we'll file each of them in wherever we can. And it might be that this business unit is the business unit that have the legacy products. They have the most history, but not the product that belongs to the future, and they are the most valuable. So in some case, it's nice to look, but it contradicts the concept that actually the new concept or new idea or something that will go for the future has less money, and they will invest 1, 2, 3, 5, but not really big business. They will say, hey, sure, why not? 50 patents, it's okay, we have the money.
Yeah, but if you're looking for that type of a patent, if you're trying to find a patent that covers a specific technology area, you're not looking in a big portfolio. You're doing a more surgical search where you're searching by that technology area, and you're harvesting patents across a broad list of assignees. So I mean, if that's the context in which you're hoping to find patents, you're going to do a completely different type of search. Those portfolio deals are a different beast entirely.
From my perspective, again, I said this before, it's a matter of managing the transaction. The sellers have to understand that if they don't do a lot of the work for the buyers aren't going to pay any attention to what they're doing. And we are actually working on a project now to get a large group of corporate buyers together to demand that the data be presented to them in a certain way and include certain things. And the claim charts must be in a certain format. One reason is because the buyers are just flooded with incoming packages, 95% of which are, to use the term of art, crap. And so the question is, who's got the burden? Is it the buyer that has the burden of figuring out where the jewels are? I don't think so. Not the way I'd like to see the process run.
Thanks.
Sorry.
I guess it's sort of case of a FUD, fear, uncertainty, and doubt run amok. When you have like portfolio out there, 10,000, 20,000 that can cover all kinds of different technologies, then I guess what's going for the seller is that, hey, if you don't buy this, I'll just sell it to a bunch of different NPEs, and it's going to create a problem for you. I think that there's a certain that type of mentality out in the marketplace after last year's, I guess, some blockbuster deals. And then also nowadays I get approached with the people who have just patent applications, and they expect me to pay top dollars for those patent applications. And I ask them, are you sure the patent is actually going to issue? Like, oh, absolutely. And can you tell me what the scope of the claims would be? Well, I think they'll be very broad and very valuable. Like, please come after patent issue. That way I can at least look at the claims and figure out what the valuation might be. But so.
Yeah, one of the interesting things that has come from all the publicity is it has bred some more irrationality in the seller's eyes. We track the data of asking prices on portfolios that are available for sale in the market, and post Google's announcement of their stalking horse bid, asking prices have doubled on portfolios. The good thing is the market actually is aside, of course, obviously if you have a core LTE patent, you can command a premium, but on everyday transactions, the market's actually holding pretty steady on price. That, I think, it's actually a really good sign for a market developing, is that you can look at it and you can say, well, price is staying relatively stable. A lot of that is also driven, though, by been a big flood of supply into the market too. The amount of available portfolios available on the market over the last year are up almost 50% over the prior year. So again, it's a good sign. To the asset class point is that you are starting to have some of the fundamentals of a basic market system where supply and demand are driving price.
Well, let me give you one data point which just sort of underscores the difficulty in valuation. I was involved in the Nortel case, and there was one telephone conversation before the stalking horse bid went in, and which I think surprised everyone by virtue of its amount. And so we're on the phone, and I remember the discussion was whether they were going to carve up the portfolio into pieces or sell it as a unit. And I remember asking the guys at Lazard, well, if you sell it as a unit, what do you think it's worth? And keep in mind, this is the seller talking. And they said, well, we think it could be almost $1 billion. So the seller undervalues its own property by 4.5 times. What does that tell you about precision of valuation?
Yeah. But I think the trend is that actually, as what Kevin said, I think there was definitely a bubble. I don't think the valuation, the crazy valuation of Nortel is going to hold. Novell sold about 886 patents for $450 million. That's about $510,000 per pop. Nortel, 6,000 patents without your concern about the U.S. patent versus foreign patents, 6,000 patents for about $4.5 billion. That's approximately $750,000. And I guess one thing that really caught people's attention was Google's purchase price of Motorola for $12.5 billion. Now, let's ignore what Michelle said about, hey, we bought a company for reasons other than just for patents. Let's say Google just purchased the Motorola for patents alone. 24,000 patents for about $12.5 billion. That's going back down to $510,000 per patent or patent application. But you have to also figure in, now, let's not ignore Michelle. There's such a thing as an operating company called Motorola, which invented cell phones, had generated about $11 billion in revenues in 2010, and has about 19,000 excellent engineers. So all of a sudden, you know that in Motorola deal, Google paid far, far less for each patent than Nortel. And I guess another indicator is digital stocks. I think right after announcement of Google Motorola deal, I think their stocks, the market valuation went up to $4.5 billion. Today it's back down to $1.8 billion. So I think there was a bubble now, and I think market actually come back down to, I guess, where it was. I mean, I'm going to say one more thing about how crazy things were. I think right after Google Motorola deal, I remember reading a newspaper account where supposedly one of the financial investors in Kodak was saying, you know what, I think based on all these transactions, I think our stock, our patent portfolio is worth a lot of money, and I'm going to, and if a Kodak management, I think they were trying to sell their patent portfolio at the same time, and this financial investor was supposedly said to the reporter that if a Kodak management sells the patent portfolio for less than $6 billion, I'm going to sue them for malfeasance. To me, that's kind of crazy talk, but anyway.
Bruce?
Ron, as you and I have discussed many times, and as you started off here, there are really two issues in all of these things. One is what's the worth of the patent, and that's completely dependent on the buyer. There's no value outside of what it's worth to the buyer. And then the second issue is how much is it going to cost? How much you're going to have to pay for it. Those are two completely independent things. But the other piece is that in all of these transactions, you have to take, it's all uncertainty. There's no single number. And what you have to look at is what's the sensitivity to the various probabilistic assumptions, and do they in fact run up against the price?
Yeah. Yeah, and I think the uncertainty is interesting because as many of you know, there's a lot of institutional investors, hedge funds, and private equity that are interested in this asset class, in quotes. But they're going to have to get comfortable with the level of uncertainty. There's a general misperception that investors, professional investors, are averse to risk. They're absolutely not averse to risk. In fact, the hedge funds make their money on risk. What they're averse to is risk uncertainty.
Yeah.
And can we ever lower the uncertainty to a point where this is going to become a tradable asset in a mainstream kind of a way?
I don't think so. Because it's always going to be uncertain. In addition to legal uncertainties, you've got all the market uncertainties, you've got all the player uncertainties. You don't know what the markets are going to look like in 2 or 3 years or 5 years, which is when the value really comes into play. It's not going to get there.
And there's we use at least 24 risk factors to do the discount analysis for specific to patents. Design around risk, invalidity risk, obviously. Bad Markman ruling risk. How in the world do you quantify those?
Careful.
Okay, well let's see. We talked about diligence. Let's come back to this notion of average price per patent. People seem to be taking this now as the holy grail. Is this really a meaningful metric to be comparing a sale of 24,000 patents against a sale of 18 patents?
I don't think so. I mean, average. Well, let me take that back. Let's see. It is used by some sectors. I think after all this craziness that are going around the market, I think the conversation with the potential seller around summer of last year, started like, hey, I think Microsoft and Apple and Google, they pay anywhere between $500,000 to $750,000 per patent. Our patents are worth a lot more, so let's start with $1 million per. And that was how I guess the conversation went. But as we, with those sellers, as you go further and start looking at their patents closely, I think a lot of those conversations tend to disappear because you start pointing out issues with their portfolios. But I guess that type of data is being used as a starting point, but at some point, it's just not going to hold.
Yeah.
We use it as a sanity check and as a way of a common dialogue with, we're usually on the buy side, and we usually use it as a common dialogue with the seller. So we value the portfolio we're purchasing. We have our gems, we have our value drivers, we have our bulk. We come up with the offer that we think makes sense to us. But then when you present it to the seller, you're not telling him which patents you really want. You want to kind of keep that close to the vest. And so it does end up coming out as an average price per patent, or that's how when there's a disconnect, the seller will say, well, that's only $300K per patent, and we need more than that. And they understand everyone understands what's going on, but it's just a convenient way to have a discussion without tipping your competitive interest in the portfolio you're purchasing.
Yeah, I think it's a data point that it's never going to drive evaluation, but it is a data point that can be helpful, and it's more helpful on the really large portfolios. So it's less helpful on the small portfolios.
It's a negotiating tool.
Yeah, it's a negotiating tool. It's yet another data point you can use. You can also use walk them through like what does litigation really look like, and what's your real probability of success, and what will you actually get at the end of that. I mean, you can walk through, but those are all tools to help hopefully ground the buyer. But some people are really fixated on it. I will say there are corporate sellers out there, large corporate sellers out there that have got it in their mind. And it's fascinating to me because they must have it in some of their MBOs where get average price per patent above X. And what we've been able to do is they shop a portfolio of 30, 50 assets, and they're really fixated on this average price per patent, and believe it or not, they'll actually allow you to cherry pick the best assets out of there, which is great, because then they can get higher price per patent, and then you don't have to buy the bulk, shall we say. So
we like sellers that use that metric, because then you can just find the patents that you think are dynamite, and they're not really focused on that. They're not really trying to evaluate and differentiate between their assets. They just have a pool of patents that they don't need. They've been charged with selling them, and those are great sellers to work with if you represent the buyer.
I wouldn't advise it if you're representing the seller.
Yeah.
I have a question.
If you're a buyer and you've done the evaluation of the patent, and then later you're in litigation asserting that patent against someone else, has anyone ever then tried to get in discovery your valuation, and has that been then used against you?
When I used to run Yahoo's defensive IP litigation, and I wanted that information desperately from every NPE, and I never got it.
By the court?
Yeah.
They just said no.
Just not relevant.
Not relevant is the key. The question is, even if you got it, what does it mean? And the usual argument is that what you paid before litigation is a risk-loaded number, and as you move through the litigation, the risk goes down and down and down, and so it's okay that you're asking for damages that are 100 times what you paid, because your purchase price was risk-adjusted and the risk is gone now.
Could you ever envision some court then starting, if you're having large numbers and you're getting values per patent, could you envision that then there would be some experts saying, well, there's actually a market out there that's now been developed, and so now let's have some market-driven data?
I personally would love to see
Yeah.
that world evolve. I mean, as someone who spent 5 years in the defense side, being, having the NPs coming at me, it was very troubling to me that I knew that patent had been purchased for $1 million at the Oceantomo auction, and I was being asked to pay $20 million for a non-exclusive license to it.
And you
That
could
just
never
seemed-
bring that in.
It made me feel like the patent system was very broken, that was the way that it worked. And so I think, getting a nexus between the purchase price of an asset and what you can charge in rent for it, I think that's something that needs to happen.
Maybe some professors can do a study on that.
Are there any in the room?
Yeah.
Any brave ones?
Or maybe a judge will allow it into evidence.
I have a question in this context, I think. So I'm a patent litigator. I spend a lot of time looking at prior settlement agreements, but typically I cannot share that information with my client. And you guys were talking earlier about how comparables are such a tricky business. Well, the kind of counterexample to that, special counterexample, is where it's the exact patent portfolio as prior licensed, right? And my clients would love to know, what the other folks in their industry paid for this portfolio before them, but we can't tell them. And in some instances, where the prior license agreement includes a clause that says that it can't be produced except under a court order, we have to issue a subpoena to the non-party to get the plaintiff in the case to produce it to us. And sometimes even the non-party will file for protective order to prevent that disclosure, right? So, it seems to me that that's another example of how the system is broken. I mean, the most relevant information for my client in terms of deciding whether they're actually going to be making a mistake agreeing to whatever the plaintiff is asking for are those prior settlements, and they can't get them, right? I mean, we could sort of you're getting warmer, you're getting colder, but that's about it. I mean, any comments?
No, and also, I mean, to me, the settlement agreements are the best indicator of the value of a patent in a litigation context. It's not the arm's length transactions that were done, when you weren't faced with litigation, but those aren't admissible either. So it's
I wish some of the folks I know in this room who are knowledgeable about antitrust could say something about this, because I have a feeling that the part of the reason, at least, that it's the only outside counsel that gets to talk about this stuff is that the in-house counsel is very fearful about any kind of price-fixing claim that could come about, right? And so it seems like this is an area where antitrust law type theories, at least, are preventing the patent market from developing in an efficient way. So.
But why can't your client just talk to the plaintiff directly without you? I mean, they'll be happy to say, this is how much I'm willing to sell a case. And your client can ask, well, how much the other guy's paying? They'll probably get the information, antitrust issue or not.
It's like Ronald Reagan says, right? Trust but verify, right? I mean, they want to see the actual agreement. They don't want to just get what the plaintiff tells them it was for. I mean, there are severe penalties if they entered into agreement and their reps and warranties were violated, I guess. But, there's
But you're trying to sell a case. I mean, it's not like, you're trying to, I mean, usually antitrust issues arises when you're trying to talk about price of product you're trying to sell, or there is some sort of collusion over, what volumes how many you're trying to divide the market. But in this case, you're just trying to settle a claim brought by a third party. And why is that a really antitrust violation for you to know what the market value of that claim is? I don't get it.
I don't know that it would be. I'm just saying that it always strikes me as bizarre how many restrictions there are on the sharing of information about past licenses, right?
I mean, especially if it comes from the plaintiff himself. I don't know. I don't think that's. I mean, I understand the concern, but I don't think that's really a discussion with the competitor about the products that you guys are competitors with, and trying to influence the price or the volume. It's really just comes down to straight settlement and litigation. I don't see really a lot of concern in that area.
So what you're saying is that as a representing an operating company, if you were to talk to other operating companies that had prior settlements in the same portfolio about exact terms, of the prior deals,
That's the information you're trying to get. I mean, I'm not sure I'll necessarily talk to my competitor, but in terms of getting that information from the plaintiff, I just, I probably want to know, that what I'm paying, what you're asking me to pay is comparable. And, usually you can get that. If the other plaintiff is not willing to give you that kind of information, then case is not going to settle, right?
Right.
They want to settle.
And I think it's just typically that, the way that these things work is like the lower exposure ones get settled first. And of course, then they don't want to tell you that because then that anchors it at a lower valuation. So there's a lot of things going on in those situations. But anyway, it strikes me that if there was some requirement that that licenses be recorded, right? And that this information will all be, that would move a lot of these negotiations upstream overnight.
I'll give you one example of how you address the issue. One is with the joint mediation. That happens all the time. That's you get room full of co-defendants who are competitors. Sure.
That's sort of what an ITC action is, isn't it?
Well, and Judge Rader is pushing this. Judge Rader is pushing mediation on the damages issue, and especially where the CEOs are in the room, because the fear is, in many cases, the lawyers aren't really painting a fully accurate picture to their client about what the case is worth.
Well, they've tried to do something like this in Delaware, right, with non-patent actions, where they've got the actual judges in Delaware arbitrating cases privately. But now they're getting sued, right, for First Amendment.
Well, this could be part of ENE, where you just get the parties in a room, non-binding mediation, and you talk about damages. The problem is the parties don't want to commit to a damages theory so early in the case.
I think, though, it highlights, again, though, it gets back to this, one of the real problems in this marketplace is the lack of transparency and the lack of data available. From our perspective, for our clients, for several of them, one of the best values we provide to them is just the information we're able to share because of our place in the marketplace, and being able to, if we're not settling a litigation for a client, being able to tell them, well, that, what the number you're talking about is generally within range of what others in the case have settled for. That's what they want to hear. And there isn't, they need that affirmation. So I think data and sharing of data, we just have to it's really driven by the operating companies. The operating companies have to get more comfortable sharing this data. And they have the power. They're writing the checks.
And it goes down to a very personal level. Nobody wants to be the person that approves the settlement that turns out to be the highest. 3 standard deviations off the mean.
I was at a panel in the Stanford Medical Center about a year and a half ago where David Kapos, who's the head of the U.S. Patent Office, was the main presenter with a number of other representatives from the U.S. Patent Office. And I think Stanford Medical Center was richly engaging the whole patent process by having him there. But there's a serious backlog, and it seems like the patent markets that you're talking about are emerging would have a very specific benefit in engaging, say, the U.S. Patent Office. And I think the whole system is under revamp at this point. I think because of partly the internet and a variety of other reasons that they're trying to change it. But to what degree are you at all engaged with, say, the U.S. Patent Office to perhaps bring some of the questions of transparency to bear in terms of valuations in any way, shape, or form, or have you observed that? And could the Stanford Law School, for example, at some point start investing in patents from the Stanford Medical Center or Stanford investment portfolio as a whole?
Our much feared patent litigation wing here at the law school.
And you would be an NPE.
Absolutely.
But not a patent troll.
No, not a troll, no, whatever that is. Well, yes.
Actually, since someone brought up something more in the biotech field where I'm from, this whole area of what you're doing with patents would be considered bullshit in biotech because the product life cycle for you is so short. There's no way for you to know what patent's going to be relevant to your product when it comes to market. And you have all these people sitting out there with filed patents that still have life left. Whereas in the drug markets for biologics and stuff, it'll take you 10 to 15 years to get something even to approaching market, in which time you will have already found out which patents are going to be relevant you've already picked what you're going to pursue. There isn't going to be, you've already done your freedom to operate analysis, so you've got a pretty clear path. So you don't run into the same type of situation where you get this run-up of 24,000 patents in a portfolio you're paying for all this money. So it is a very much risk situation, but here you're talking about such a short time cycle. So ever since they changed the law to patent life starts from the time of filing, that's eliminated one of the things that used to come up in biologics most of the time, because there was one patent that was filed 40 years ago, and it took that long for it to finally issue, and then suddenly someone was coming out with saying, well, you're now infringing on this patent, even though your product's been on the market for 10 years, this patent just issued. So I think the discussion here is...
That sounds like Mr. Hyatt you're talking about.
Yeah, but it's very much to this industry as opposed to what's happened in the medical school. So there's not going to be the same type of discussion that goes on.
Well, that's a great point, and that's a great subject. I don't know if the law school has ever done it, but the difference between what patents do in life sciences versus tech, it's a hugely different thing.
I have a book to recommend.
Yeah?
Yeah.
Is this the patent crisis,
Yes,
perhaps?
on this very issue.
Yeah,
It all depends on the industry.
Yeah, that's right. Oh, well, certainly industry to industry, but there's a fundamental change when you go from any kind of tech to life science, especially pharma, where it's impossible to separate the patent from the product. It's impossible.
Yeah, I just say my story is just 1 minute. Just say my story. I sold my patents myself without any attorney, anything. I just myself sold I'm an inventor. I sold my patent myself. My experience is patent value is like antique value. Okay, I collect antique. So for example, I collected a Rolex watch, 1885, still working very well every day. How much cost? How much worth this Rolex watch, 1885? So the patents is same and antique, right? Depends on markets. Who's going to buy it? Who's going to sell it, right? I bought this antique, still working very well. Rolex 1885 is only $200. Okay, so it depends on who's going to buy it. Okay, who's going to sell it? What's the market? What's the field? Mobile, wireless, or image processing, or just normal? Depends on market. It's no very. But averagely, I'm to be honest, I'll tell you, averagely, the patent value for the engineer side, it should be the engineer salary, like $200,000. It's reasonable, right? So I think that is technical is very important. The market is very important. So that's my just personal experience part.
But one difference with the antiques market, and I know this because my wife is in that business, is there are plenty of books you can go to and look up the prices of any antique, no matter how rare it is. We don't have that kind of price data transparency in the patent world.
From a seller's or from a buyer's perspective, I can understand how you want that information. But bigger issue is, do you really want the government requiring disclosure of the patent value, and how much having the government put a figure on that, and would you trust that? And should the government be requiring patent holders to value their patents? And that's in flux all the time. I mean, part of doing the deal, I understand if you're representing a buyer, is to get it at the best price and to get the patents you want. And if you're a seller, you want to get the best deal you can get. But it's a private transaction. At the bottom line, in the end, it's largely a private transaction. Why would you want that data so transparent? Would that really be in your client's best interest?
Well, in my view, that's where patents and the real property, that if you look at the real property market, they're all private transactions. You have comparables. It enables financing. It enables all sorts of transactions that if you didn't know how much your neighbor paid for their house, I think it would really impact the market for real property. So, I mean, even though patents are very unique and they aren't exactly like real property, I mean, there are instances where private transactions and having the ability to get to that information funds all sorts of other markets and enables it in a way that if that information was unavailable, it'd be very difficult to do.
And I just want to sort of amplify that a little bit, right? So I actually think that this is the single strongest reason we don't have a real thick functioning patent market today, right? So imagine a stock market in which no one would tell you the price at which you bought or sold a share of stock.
Yeah.
You could have a stock market that would do that. You could buy a share of Google. You wouldn't know whether you're getting a good deal or not. You wouldn't know whether it was going to go up or down because no one would tell you what the other prices were. That's the market we have right here, right? And it shouldn't surprise us that we don't actually have an efficient clearing price, that we have fewer transactions than we should. The fact that we turn to litigation as our best means of valuing and engaging in market transactions is a really bad sign for how efficient this market operates, right? So, I mean, should the government be assigning value? Absolutely not, right? It is definitely a private transaction, but, in other circumstances, whether by norm or by, in the securities case, actual requirement, we've had you publish this information. I actually think the result has been a much more efficient market.
Well, I wanted to throw out a very provocative idea that I've sort of put out there to the academic literature. It will get me, it will kick me out of the AIPLA and related organizations. But one way to think about patents as assets is that they impose costs on the society. So we tend to valorize patentees. But as we've seen in these markets, it's not clear that patents are actually improving social welfare, and they're certainly imposing, very, very high and unpredictable costs. So when you buy property, we use actually the public transaction cost to base your property taxes and other things. But we could come up with a valuation of a patent at the front end. We could say to a patentee, to an applicant, tell us what you think the value is. And in fact, we're going to use that like we use property values for taxation purposes. And we might actually say that the cost of getting this patent is in some ways related to that number. The other thing that would do is it would help the people who might be affected by that patent to screen and to say, for all patents valued at less than $10 million, we're not going to bother to post-grant review. But this is a way in which you kind of pull out the needles in the haystack. The other thing you could use that valuation number for would be at the damages stage, that you wouldn't be eligible to get damages, and we'd have to come up with ways of coming up with how we would look at damages across multiple infringers. But the idea here is to say that patents, if they really are like other assets in the economy, ought to have taxation and other sort of social costs reflected. Now, I will say that even I think this is a crazy idea, but I think what it does is it points to the idea that patents are no longer just a social good. In fact, there are responsibilities, and we ought to have ways of figuring out which are the dangerous ones. If you want a patent on a way of exercising your cat with a laser, fine. It doesn't affect anyone else. But if you want to get a patent that would, essentially stop imports of automobiles, you ought to indicate that up front, because we need to know that information if we want to have orderly business practice. I'll just throw that out there if you have any reaction.
And what's the motivation for the patent owner to disclose that number?
Well, because you can't get damages later in the game.
Cap on damages.
This would in some ways be related to some cap. So it wouldn't be that valuable to you unless you were willing to say.
Oh, that's yeah. It sort of. We're out of time, so I'll close on this kind of ridiculous analogy. But I remember in France during the Mitterrand administration, they were trying to reduce government expense, something that everybody's interested in today. And so there was a proposal, and I think they actually did it, to get rid of all of the property tax assessors, and everybody could file their own estimate of what the property was worth. And the government could either tax you at that number or buy it from you at that number. Self-enforcing. Thanks very much.